Or what are you going to do? Thank you very much, the Chairman. I think that's a very important question. In that my personal view is that it is not a right of government to always win cases, but government will win or lose cases depending on how much legal advice the particular entity within which the dispute is located. If it is, say, for instance, the Ministry of Trade or Ministry of Finance, it is important that all those departments, first and foremost, before committing government to anything, must seek legal advice. Of course, once the advice is sought, it may or may not be acted on. But of course, with the attendant risk, when they don't act on those opinions, that they could easily find themselves on the receiving end. And in a number of cases, in fact, in the majority of cases, government has found itself on the receiving end because the Office of the Attorney General is brought in many of those cases at the tail end. It is not involved at the time when the government was being contracted into some particular activity. And therefore, my personal view about this is if we have a robust, integrated legal management system which will sift through all government departments, just like we have IFMIS. It helps the principal legal advisor to government to know at every stage, at the earliest stage, what government is about, to what kind of arrangements or engagements the government is about to enter into, and advise appropriately. And therefore, I myself, in a proactive way, assign implementation of various laws is under the constitution given to the president. And actually, some of it, like you may recall, when you enacted the Marriage Act the other day, you placed its administration under the Office of the Attorney General. Parliament actually did that, which is within its power to do. So I believe that what perhaps we need to do is to bring in policies that bring the Office of the Attorney General to its rightful place. And for me, my view, Mr. Chairman, for instance, is that the Attorney General's office, the state law office, should be like a premier law firm. It should be the place where even citizens would feel inspired to visit to seek legal advice. I believe that kind of position has been eroded over the years, partly because of inadequate funding, and in fact, Mr. Chairman, the recent complaint from the Office of Attorney General has been that they train state councils, and they end up losing most of them to, most interestingly, Mr. Chairman, to Parliament, to the judiciary, and to the ODPP. That is a matter that really the Attorney General should be able to address. It cannot be accepted that people will move from the state law office to go and work in the judiciary merely because maybe the remuneration is better, or the working conditions there is better, or go to the ODPP. But honourable members, because I will be making proposals on budgetary allocation, you just need to walk to that place. I have not been there, Mr. Chairman, for a long time. But when I went there, I wondered where it was that I was going to. Because it looked like it's a very small place. But it is a place where there is so much that touches on almost every arm of government. Yet it has not received the kind of requisite attention that is necessary to give it pride of place. be pleading with members, particularly the National Assembly, to see to it that that the other place is elevated, and even to retain qualified and experienced professional staff, and people feel inspired. If you had to look at where they conduct marriages, it's like a small cubicle that nobody would even want to sit there for more than 20 minutes. You feel that you might find the cockroaches around. It's very pathetic. Mr. Chairman, there was a question by the Honorable Kosing, member for Pokot South, on the summoning of CSs. I think there is no conflict, because Article 125 talks of either House of Parliament or its committees can summon any person to appear before it, to give information or evidence. Now, remember the argument, Mr. Chairman, which I have been raising over the years, has been when it says either House of Parliament, where does the House of Parliament sit? It sits in plenary, because there was the issue of committees. So I think all we need to do is just organize ourselves a little bit well, so that everybody sticks to their mandate. I know the question being raised by the member for Pokot South is one that he has witnessed a lot of problems in dealing with. But I believe, Mr. Chairman, with you as a speaker, we will see a situation in which people stick to their lanes, so that what is for the National Assembly is the National Assembly, and what is for the Senate is for the Senate. But should there be concurrent, because there are those issues which are concurrent, the CSA should feel free to appear before both houses. Mr. Chairman, finally, it's like of this system, is it working? Is the presidential system working? I think, given that we've had this constitution for the last 12 years or so, it is still work in progress. But we should not rush to change or try to fix this or the other until such time as we have fully implemented everything under the constitution itself. But I think it is possible for everybody to obey the law. The Honorable Caleb Amisi, Mr. Chairman, was concerned about the executive particularly not respecting the other arms of government, the judiciary and parliament. And I want to say, well, sometimes it could be a matter of body chemistry. That maybe somebody felt that certain decisions were not favorable. If we don't implement them, then it means that we are wasting taxpayers' money, getting committees of the House, and the House coming to adopt those reports and make certain findings. I think it's only fair that there should be a mechanism. I know in the past there used to be something which was called Treasury Memorandum on Implementation of past reports. I think we should go back to be acting in vain. If Parliament has recommended something, I think it's only fair. If somebody, the implementing agency, thinks that there are difficulties, they should again appear before Parliament to explain those difficulties, or why they are not able to implement what Parliament adopted. Thank you, Mr. Chairman.
Thank you, Muturi. Can I ask you a simple question? You and I have a history of having been magistrates, and when we were, you may recall, at 9 on the dot, you are on your bench. 2 on the dot, you are on your bench, dispensing justice to the public. Today, probably the only institution that keeps time in this country is Parliament. You go to court, your case is set for 9. By 11, there is no appearance of the judicial officer. Sometimes it gets to 1, you are told try at. You don't even come for the case, you try. Try at 3 or 4. and then eventually a clerk comes to announce to you that try at 3 or 4, and then eventually a clerk comes to announce to you that are you going to carry on with the inadequacy, or what are you going to do?
Thank you very much, Mr. Chairman. I think that's a very important question. In that my personal view is that it is not a right of government to always win cases, but government will win or lose cases depending on how much legal advice the particular entity within which the dispute is located. If it is, say, for instance, the Ministry of Trade or Ministry of Finance, it is important that all those departments, first and foremost, before committing government to anything, must seek legal advice. Of course, once the advice is sought, it may or may not be acted on. But of course, with the attendant risk, when they don't act on those opinions, that they could easily find themselves on the receiving end. And in a number of cases, in fact, in the majority of cases, government has found itself on the receiving end because the Office of the Attorney General is brought in many of those cases at the tail end. It is not involved at the time when the government was being contracted into some particular activity, and therefore, my personal view about this is, if we have a robust, integrated legal management system, which will sift through all government departments, just like we have IFMIS. It helps the principal legal advisor to government to know at every stage, at the earliest stage, what government is about to, what kind of arrangements or engagements the government is about to enter into, and advise appropriately. And therefore, I myself, in a proactive way, propose I would introduce such a system. But of course, all that will only happen when there is sufficient funding to the Office of the Attorney General. And this, of course, would involve not just the National Treasury, but also the National Assembly in ensuring that the office is properly resourced. But I want to agree with the Honorable Deputy Speaker that indeed government has lost in cases where, if properly advised and been sought, ab initio, that would not have happened. And I think tied to that is the issue raised by the Honorable Chomwa, the Majority Leader, the issue of those lost cases. The lost cases, I think I would myself want to deal with it as a matter that is now over and will not be resuscitating. But it is important that we appreciate that government, just like ordinary citizens, appear before courts as litigants, and should expect that in an adversarial system such as ours, they could either win or lose. But at all times, government should first receive the best available legal advice, especially before contracting. Some of the other smaller cases that government has actually lost has been, in my view, out of negligence, because many of them are either not adequately defended, and some not at all defended, and we find judgments being entered against government on account of either inadequate personnel or inadequate preparation by those charged with defending government positions in courts. With regard to the question of abuse of the justice system,
maybe Honorable JB did not get my question. Maybe I could paraphrase it. My question was, and truly what you are saying is true, that some of the cases could have been lost by government because of negligence by officers in the state law office in not defending government properly. And therefore government has been surcharged, or rather has judgments against it that amounts some that are obscene for some cases. And cumulatively, if you look at all those judgments, I think they're moving close to 1 trillion shillings. And my question was specific. As AG now, knowing, as you say here, that there might have been negligence by state law officers in defending government, what do you intend to do? Because we cannot subject the Kenyan people, the Kenyan taxpayers, to pay those huge bills out of the negligence of officers in the state law office. So what do you intend to do if you are approved as the AG to make sure that you save on taxpayers' money, not even government money, on those judgments? That was a specific question. I wanted to hear what your intention.
No, on those judgments, if they have been finalized, there is nothing that the Attorney General will do, save to advise that the government settles those that have been finalized. Those that have not been concluded, of course, the Attorney General will take up the matter and apply the best foot forward in ensuring that government gets the very best out of them. But I'm saying, moving forward, not the historical ones, going forward, I think there is need for all government ministries and departments to ensure that they involve the office of the Attorney General, especially before entering into commercial contracts, because some of them are entered into. The brief that I have is that some of them come to the office of the Attorney General, and the Attorney General's office looks through them and begins asking, why did you enter into this kind of arrangement? It is obvious that you are going to find yourselves in a mess. Some of them, like the construction contracts, you find that maybe some functionary in a ministry may not have been happy about somebody who was awarded the contract, and feel because they come pushing their way forward and say, terminate this. Obviously, with the consequences that the party that is aggrieved will go to court. And chances are very high in those kind of situations that government will lose. So that's why I'm saying, going forward, it is important that we have a policy understanding that the constitutional mandate of the Office of the Attorney General to be the principal legal advisor is taken seriously by all government ministries and departments, so that we are able to avoid some of these losses that impact on even our economic performance. Of course, with regard to the criminal abuse of the criminal justice system, it's only fair that everybody appreciates that even though the Attorney General coordinates some of the activities within the criminal justice system, criminal prosecutions are undertaken by the DPP. And as you know, in the performance of his functions under the Article 157, he is not under the direction or control of any person or authority. But I think, working collaboratively, it is fair that in a democratic country, we need to appreciate that people may hold differing opinions from even you as a member of parliament, or even you, the Attorney General, and that does not in itself entitle the party that feels that they have weight and power to use the criminal justice system. It is just a matter of discussions and agreeing with people that going forward as a country, let us embrace the divergence of opinions, and it's not a crime On the pending bills, Honorable Shomwa, the report I have is that a task force had been set up, which came up with a report indicating that the pending legal bills arising out of court judgments currently stand at about 151 billion. Of course, this is a strain on the exchequer, but unfortunately, ministries do not budget or they don't provide for these debts. Yet there are debts which must be settled. Some of them, the smaller ones, which is really the more pitiful situation. You may find that some judgments have been entered against government. Maybe some government driver went and knocked somebody, some citizen somewhere. They went to court judgment, and for well over a decade they have not benefited from those judgments. It's really an unfortunate situation that, in my opinion, should not happen. But I would be advising that they make provision. But of course, the Honorable Shomo, having been the chair of the Budget and Appropriations Committee, is aware that some of these matters, when they appear before the committee, they don't look very urgent. But I think I would be appealing to Parliament, particularly the National Assembly, to look into some of these matters favorably. The Honorable Opio Wandai, the minority leader and member for Ugunja, raised the issue of the criminal case that was filed against me. I just wish to inform the committee that, through you, Mr. Chairman, that that case was dismissed at no case to answer. In fact, in the judgment, it was described as one built on quicksand. The Attorney General's office, which was, and it's unfortunate, I didn't want to go to this, but I must say it to clear there. The Attorney General's office, which at that time was responsible also for criminal prosecutions, appealed. And I was not surprised that they were appealing because the case actually originated from them. They knew what it is that were pursuing against me. But again, the appeal was dismissed by the late Honorable Justice Oguk. So nothing really came of it. Vetting by Justice Rengera, it was something which was famously known as radical surgery or surgery by radicals. Unfortunately, when that surgery was happening, I was a happy member of Siakago constituency in 2003. And he needed to come to Bunge to deal with us differently. So I did not have to be taken to him. The Honorable Opio Wandai, Mr. Chairman, also raised a very pertinent issue about the issues of human rights and democracy. And as you know, if you look at the functions of the Attorney General, one of it is to advise the government on the issue of human rights. In fact, the Department of Justice within the Attorney General's office specifically deals with that issue of advising government on matters of human rights and democracy. And therefore, you can expect that there will be robust engagement with the various arms and various actors. Remember, one of the reports that the President has to deliver to Parliament and Article 132 is one showing what steps the government is taking towards implementing the many values contained in Article 10, which include, among others, human rights and the enforcement and implementation of international treaties. And therefore, when that happens, the President usually is advised from the Attorney General's Office, Department of Justice, on the steps that have been taken. But to go further, It's also to inform the committee that if you look at Article 59 on the establishment of the Kenya National Commission on Human Rights, one of the issues that commission is charged with is the enforcement of issues to do with human rights. And so it's an independent commission. That commission works in close cooperation with the Office of the Attorney General with regard to matters to do with human rights and democracy. There's a question about Mr. Oduor Onwe about a position I took in regard to some demonstration that was happening in the university. I can inform the committee that that was approximately 41 years ago. I suspect not very many of us were born, but it's just a matter of expressing a divergent opinion. There had been no formal body at the university since the proscribing of the body that was loosely called SRC, the Students Representative Council. And as the chairman then of the Kenya Law Student Society, I was co-opted into it. In that body, we had debates, very robust debates, and some people took a position that we needed to go to demonstrate. Some of us who were just exiting university were the contrary view that we didn't think we had the luxury while we are preparing for our exams to join the rest in the streets. And therefore, I'm surprised that Mr. Ongwen thinks that that was betrayal of democratic or anything progressive. I don't know what could have been described as progressive then. I suspect he was not even in the university at that time. He must have heard rumors about what happened. But you know, this is the beauty of our country in a democracy, is to allow people to express themselves whichever way they choose. But as the Attorney General, I would defend his right to continue saying that, as much as I continue also saying that it was not progressive. So it's here not, Mr. Chairman, is not something that I think would reflect in any way on my suitability in the office of the Attorney General. Mr. Chairman, the last question was by the member for Kathiani, the Deputy Minority Leader, the Honorable Robert Boy, on the defection of MPs. I think, Mr. Chairman, when we talk about, when you go to Articles 36 and 38 of the Constitution, it becomes quite clear that every person, every adult person is entitled to those rights. And I think we need to appreciate that our Bill of Rights is one of the most progressive and robust in the world. And it is no wonder that given the history, the political history of this country, before the promulgation of the current constitution, we Kenyans felt that there was need to place almost everything without exception in the Bill of Rights. It's actually the longest chapter with a total of 41 articles. So everybody has a right to form and be in a political formation. When that person decides that they no longer want to be in a particular formation, I cannot myself be persuaded to say that they cannot. Of course, the attendant issue that goes with that one is the party the political party would then be at liberty, using its internal processes to discipline any member that it feels has in any way injured its position, not just in Parliament, but anywhere. Remember, when we were doing the Political Parties Act, Mr. Chairman, we went to great lengths to provide even for disciplinary mechanisms that a political party should follow in dealing with members whom it may deem errant. And of course, going on to even provide in Article 103 what should happen in the event that the member is a member of Parliament. But I'm willing to engage on the technicalities that are there, but for now, suffice to say that I think a member is at liberty to choose to make decisions as they find appropriate. And if the party to which they belong feels aggrieved, then the party can proceed to take necessary disciplinary action. The Honorable Robert Boy, Mr. Chairman, finally asked the question of my view on the dropped charges. I think I'll express myself in general terms because, again, that is the domain of the DPP. Even though, as the AG chairs the National Steering Committee on Anti-Corruption, which brings together many bodies, including the DPP. But again, since the reasons that informed the DPP were not made public, it will be, I think, premature to start 30 minutes after the appointed time. You just disband, you adjourn. In the case of courts, I think it is something that we really must work as a policy. That in fact, being late, and during our time as we brought it to hear you, the first thing you said was to apologize to the assembled litigants and counsel, because we always felt it was, you have done something so abominable that you want to apologize to the people in the court. Today, I think Judicial Service Commission should revisit those because these are just standards really. And we talk about backlog of cases. Some of it, the contributor is this non-appearance by judicial officers or lateness. I think there has not been sufficient monitoring of the conduct, we would call it the conduct of judicial officers when dispensing justice. And that, in a way, has contributed to both, with respect, sometimes you look at the quality of the output and you wonder whether the people making those decisions are really vested in the same institutions as you and I did. And it's a matter that I intend to, again, it's just to make suggestions because for the betterment of this country, for the good of the entire country. And I agree with you, Mr. Chairman, justice delayed is justice denied. We, judicial authority, again, judicial authority is derived from the people. And the judicial officers cannot imagine that they are supposed to lord over them. They derive whatever authority from the people. That's in Article 159. Thank you, Mr. Chairman.
Thank you, Honorable Justin Muturi, nominee for Attorney General. I'll now avail you 3 minutes to make your final appeal, if any, to this committee.
Mr. Chairman, first of all, I want to thank you and thank the members of this committee. I think this has been a very useful engagement, and you've approved. Honourable members, I promise and undertake to do my best to give the best available advice to government both at the national level and at the county level in a collaborative way, as provided for in the form of independent but interdependent. Thank you very much.
You are released to go. Honorable Muturi, thank you very much. Honorable members, as the nominee exits, we will resume. We'll break for lunch for exactly 1 hour. It's now 1 o'clock. We resume at 2 o'clock sharp. Leave your files where they are. The sergeant at arms is instructed to ensure
that I am only a citizen of Kenya.
Excellent. The David Speaker may ask you 1 or 2 other questions before we go. I'm advised we go to introductions first. I'm the Speaker of the National Assembly.